Somewhere in your paperwork right now, there's probably one small gap that could quietly stand between your children and the money you spent a lifetime building, for months, sometimes years after you're gone. It's not about how much you have. It's not about being careless with your finances. In most cases, it comes down to a single form nobody ever finished filling out. In the next few minutes, we're going to walk through 4 things that change for your kids the moment you pass away. What happens to your bank account, what happens to your house or your investments, what happens to a retirement account like an IRA once your children inherit it, and whether your estate ends up owing tax before anything even reaches them. None of this requires wealth or a complicated financial situation. If you have a bank account, own a home, or hold any kind of investment, this is relevant to you and to your kids. Let's start here, because it's usually the fastest thing to affect your children directly. When a bank learns an account holder has died, it generally freezes that person's individual accounts fairly quickly, often within days. A joint account with a surviving co-owner is typically different, since that person usually already has legal ownership and can keep using the funds. But a solo account, one with just your name on it and nothing else set up, becomes part of your estate. That means your children can't simply walk in and claim it. Broadly, there are 3 common ways an account can be set up. A sole account, with no joint owner and no beneficiary listed, becomes part of your estate. Unless your state has a simplified small estate process, that money generally has to move through probate court before your children can access it. And probate is commonly cited as taking somewhere in the range of 9 months to a year and a half nationally, sometimes longer depending on the state. A joint account with rights of survivorship usually passes directly to the surviving co-owner without probate, because that person is already a legal co-owner of the funds. A payable-on-death designation, or POD, names a beneficiary directly with the bank. When the account holder dies, that named person, often a son or daughter, can typically claim the funds by presenting a death certificate and ID, often within a couple of weeks, without probate. Probate itself isn't free. Attorney fees, court costs, executor compensation, and required appraisals are commonly cited as consuming somewhere between a few percent and roughly 7 to 8% of an estate's value, depending on the state. It's worth remembering that a paid-off home, decades of retirement contributions, and ordinary savings can add up to a large number, even for families who never thought of themselves as wealthy, meaning your children could be looking at a real cost before they ever see a dollar. Many banks now let account holders add a payable-on-death beneficiary through online banking or at a branch. It's worth noting that a checking account and a CD at the same bank are typically treated separately for this purpose. A beneficiary listed on one doesn't automatically cover the other. For brokerage accounts holding stocks, bonds, or mutual funds outside a retirement account, the comparable designation is usually called transfer on death, or TOD, rather than POD. It's worth understanding that adding an adult child as a joint owner on a bank account is legally different from naming them as a beneficiary. A joint owner has a present legal interest in that account while the original holder is still alive. Because of that, in general, an asset that's jointly owned can potentially become entangled in that child's own legal or financial situation. For example, in the event of their own creditor claims or legal proceedings. This is simply a legal reality of joint ownership. A separate legal tool, a power of attorney, exists specifically to let someone manage a parent's finances without becoming a legal co-owner of the money. Whether that or another structure fits a given family's situation is something to work through with a qualified professional. It's also worth knowing that a safe deposit box is typically sealed by the bank once it learns of the box holder's death, and reopening it often requires the same kind of court authority used to unfreeze a frozen account, which can create a frustrating situation if a will is stored inside that same box. Beneficiary designations also don't expire on their own. A name entered on a form years or decades ago, an ex-spouse, a parent, a sibling, generally remains the legal instruction the institution follows, regardless of what a current will says, which matters if a parent meant for the account to go to their children. Now to real estate and investments held outside a retirement account, because there's a tax rule here that directly affects what your children keep after they inherit. It's called the step-up in basis. When someone dies owning an asset like a house, stocks, or mutual funds outside a retirement account, the IRS generally resets that asset's cost basis to its fair market value on the date of death, rather than what was originally paid for it, potentially decades earlier. In practice, that means a child who later sells an inherited asset is typically taxed only on any growth that happens after they inherit it, not on the appreciation that built up during the parent's lifetime. This rule is specific to assets outside retirement accounts. It generally does not apply to traditional IRAs or 401ks, which is where the next part comes in. A house, like a bank account, can also end up in probate if there's no joint owner and no beneficiary named on the property. And since real estate is often the largest single asset in an estate, this is frequently where a large share of probate costs originate before children see anything. A separate legal tool exists in many states for real property: a transfer-on-death deed, sometimes called a beneficiary deed, which lets an owner name who inherits the home directly on a deed recorded with the county, bypassing probate. As of 2026, roughly 30 states plus Washington, D.C. permit some version of this tool, though exact rules vary by state, and a living trust is a comparable option in states that don't offer it. This next part is one of the more misunderstood pieces of current tax law, and it's directly relevant in 2026 for any child who has inherited a retirement account. Back in 2019, the SECUR Act ended what's often called the stretch IRA for most people who inherit an IRA from someone other than a spouse, meaning a parent's IRA passing to a child. Before that law, a child could spread withdrawals and the associated tax bill across their own lifetime. Under current law, most non-spouse beneficiaries, including adult children, are instead required to fully empty an inherited IRA by the end of the 10th year after the original owner's death. Here's the detail that catches a lot of families off guard: whether annual withdrawals are also required during years 1 through 9 of that 10-year window, not just by the final deadline, depends on one specific fact: whether the parent had already reached their own required beginning date for withdrawals before they died. Final IRS regulations issued in 2024 confirmed that when that's the case, the child inheriting the account generally must take a distribution every single year throughout the 10-year period, not only at the end of it. For the 2021 through 2024 tax years, the IRS temporarily waived the penalty for missed annual distributions while this exact rule was being clarified. That waiver period has ended, and the annual distribution requirement is now being enforced. If a required annual distribution is missed, current law generally allows for an excise tax penalty of up to 25% of the amount that should have been withdrawn, potentially reduced to around 10% if corrected within a limited window. For a child in this situation, the two governing facts are whether the parent had already begun required withdrawals before they died, and whether an annual distribution applies for the current year as a result. Details that vary from account to account and are recorded with the institution holding the inherited IRA. Finally, there's the question of whether an estate itself owes tax, separate from anything a child personally owes. For deaths occurring in 2026, the federal estate tax exemption is $15 million per individual, effectively up to $30 million for a married couple through portability, a threshold made permanent under tax legislation passed in 2025. For the overwhelming majority of families, that means no federal estate tax applies at all before assets reach their children. That said, the federal number isn't the only one that matters. As of 2026, roughly a dozen states plus Washington, D.C. impose their own separate estate tax, and a handful of additional states impose an inheritance tax paid by the person receiving the assets rather than by the estate. And these state-level thresholds are often dramatically lower than the federal exemption. Oregon is a commonly cited example. Its state estate tax exemption sits at $1 million, not indexed for inflation, meaning a paid-off home plus a retirement account and some savings can realistically cross that line for an ordinary family. Other states set thresholds anywhere from around $1 million up into the multi-million-dollar range, so what a family's children might actually owe depends heavily on where the parent was domiciled or owned property. Put together, these four pieces: how your bank account is titled, how your house and investments are held, how the inherited IRA rules apply to your kids, and whether your state imposes its own estate or inheritance tax, form one connected picture of what your children actually experience the day you're gone. Whether an account reaches them in 2 weeks or sits frozen for the better part of 2 years, whether a house passes with a clean tax slate, and whether a state expects a tax bill the federal government never would. All of it comes down to structural details that are usually invisible until the moment your family needs them. This video was created using AI-generated narration and is provided for general informational and educational purposes only. It does not constitute financial, legal, or tax advice, and account structures, probate rules, and state tax laws vary and can change. Please consult a licensed financial advisor, estate attorney, or tax professional about your specific family situation before making any decisions. If this helped, share it with a parent in your life who has a house, a retirement account, or a bank account their kids haven't talked with them about in a while. I'll see you in the next one.